that you have enforceability only after a homologation process, so you have to go through some extra steps, and also to some extent in the Singapore Mediation Convention. And then we have this no direct enforceability, so you only can enforce it as any other agreement. Then we have a res judicata or estoppel effects, and there we could sort of that stops you from bringing a new regular action, and it could be a sort of regular res judicata effect that you say that this is identical issues that have already been settled, as it is for arbitral awards. But it could also be that you say that if you agreed on this recently in, for instance, a mediation process, you have no legal interest in litigating it. And of course, then you could claim that there has been a change of circumstances and so forth. But I think this kind of exception also applies for regular rulings. So while some people argue that res judicata effects should be lesser, and I think also the European Court of Justice has done so for court settlements. I see no real point in this. At least you should stop re-litigation where there is no legal interest in opening an already settled issue. And again, other effects could be that you basically consider court proceedings to be appellate proceedings. This is done very much in Norway. So where you would have often on a contractual basis, and these are sort of general contract terms that are used within specific fields and trades, that you there agree on ADR mechanisms, and then courts will treat appeals against these or cases brought where the parties have already been to these out-of-court proceedings essentially as an appellate proceeding. And the same thing goes for consumer dispute resolution, where when it comes to courts, and almost all consumer cases have already then been to this kind of consumer dispute resolution or other kind of dispute resolution process when they enter court in Norway, then what courts would do is they essentially treat the case as an appellate review, and they start by looking at the outcome of the consumer dispute resolution, or for instance in a rental case, the assessor opinion or decision in the case. And of course, one could also agree on non-procedural effects. So if one party then challenges this, whether it's a binding decision, sort of procedurally binding decision, or only contractually binding decision, then or not binding at all, if one party challenges it, then and doesn't comply with it, then that party has to carry all costs, or at least if you don't receive more than a 10 or 20% better deal. And this is the case in Norwegian Financial Services Consumer Dispute Resolution body. It does not have decisions that would be treated binding as a judgment, but rather as a contract. And if the financial company wishes to bring it to court, the financial company is by contract with other financial companies liable to pay the costs of the proceedings, regardless of whether it or the consumer prevails. So this is one way of actually then pushing financial services bodies to accept their trade, this consumer dispute resolution, ADR process outcomes. So they will only challenge them if they find that there's something seriously flawed with them. And then, as I said, we have these different kinds, and I already mentioned the sort of that you could have a homologation process, you could have one that really brings true estoppel effects without the parties having to do anything, and then you could have these no effects of such, but you could have on a contractual basis some kind of penalties or sanctions against a party that does not comply. And again, if there is some kind of procedural effects, be it direct enforcement or then the kind of res judicata or estoppel effects, it would be important for courts or enforcement organizations, bodies, to at least perform a minimum control. And of course, the nature of the control of the proceedings and the outcomes is highly contextual. It depends on the process, but also on the parties and their power differences. Whether we talk about consumer law, whether there are other third party or public interest at stake that could influence how and whether, what kind of standards we should put for the proceedings and what kind of outcomes we can accept. And if it's sort of consensual, so it's an agreement or contract that is the outcome of the process, then of course free and informed consent is important, and otherwise that there are some minimum due process requirements that of course depend on the nature of the case. And of course that the third party must be unbiased, neutral, and there must be adequate recourse mechanisms against third parties who are not doing their job or who are in some way not neutral or not biased. And sometimes, of course, this could be, if it's a consumer or an employee, it could actually be acting slightly in favor of the weaker party. And then, of course, if we're talking about enforceability, then also some kind of control of the contents, whether it's unlawful or not. And again, here we can, I think, look at what we do with arbitral awards and see that that gives us an idea what kind of objections one could have against the contents. And of course, again, it depends on the parties and the nature of the dispute, how much and how intense control courts should exercise. And then the court should understand also the process, because they cannot exercise these rights or duties to control and minimum control of the process and the outcome unless they understand the nature of the process. And that brings us to where I started. What kind of process is this ADR process? And this, again, is then the whole challenge of the ADR field, that it's difficult when we talk about very different kinds of processes and also very different kinds of cases. And here again, if it's highly institutionalized, it's much easier. For instance, Norwegian courts know and understand the most commonly used or all the commonly used ADR processes. So for them, sort of understanding what happens there and the nature of the outcome is relatively easy then. And then when it comes to ad hoc forms of proceedings, then it's of course much more difficult. But there again, if these ad hocs are mainly used by medium to large size businesses, then the need for controlling the process and the outcome, except for sort of unlawful or content or content that clearly violates important public policies, is then a different case. And finally, then, of course, there should be possibilities to ensure this fair trial rights, also to holding individuals who act as third parties in ADR, and also institutions providing ADR services liable for the quality of services, for delivering a good process according to, of course, the nature of processes, the process that the parties have agreed to, and also delivering the type of outcomes, be they interest-based, professional standard-based, law-based, or any mixture. And of course also for neutrality and for delivering a timely process, and also within the financial limits or whatever sort of boundaries that you could think that this kind of dispute, what it's natural to spend on trying to resolve it. So that was a quick walk through some issues related to ADR processes. Let me see.
Thanks a lot, Anna.
Thank you.
Thanks a lot for your paper, which moved the attention to something which actually avoids civil proceedings. And gives another little mosaic in the picture that we are trying to figure out today. And we now turn to Luca Penasa from the University of Udine, who will talk about the debated nature of forum selection clauses, which is somehow related to Anna's topic concerning agreements on forum.
Thank you very much, Michele, and good afternoon to everybody. First of all, I would like to express my gratitude to my friend and colleague Alessandro Fabbi, who has kindly invited me to take part in this prestigious international conference with such learned and authoritative speakers, me apart. Secondly, I would like to apologize for my Italian English. Over the years, I have tried to tame it, unfortunately, without too much success. Anyway, in my speech, I will discuss the nature of jurisdiction agreements in civil law systems, and then answer the question whether they are only procedural or also substantial in nature. In this speech, I will assume two premises, which unfortunately I do not have time to discuss now. The first is that the nature of a choice of forum agreement, and more generally of a legal act, depends on its effects. The second is that an agreement which gives rise to rights and obligations for the parties has always substantive and not procedural effects, even if it obliges the parties to make or omit a procedural act. On the basis of the first premise, our question can be rephrased as follows. Do jurisdiction agreements have just procedural or also substantive effects? In order to answer this question, we have to bear in mind that jurisdiction agreements are typical legal acts with typical effects. They are norme dispositionen, agreement changing procedural rules, using the terminology proposed by Gerhard Wagner. These agreements, therefore, have only the effects provided for by the international, European, or national rules that govern them. According to these rules, such agreements have the effect of prorogating or derogating the jurisdiction of the courts of one or more legal orders, with the consequence that these courts are obliged to decide or not to decide on the merits the disputes covered by the agreement in question. On the contrary, these rules do not provide that the agreements create rights and obligations for the parties, not even by implication, since such rights and obligations are not necessary for the agreements to produce their typical procedural effects. We can then say that jurisdiction agreements, as such, have only procedural effects and are therefore exclusively procedural in nature. Nonetheless, the parties to a choice of court agreement may also give rise to rights and obligations to seek or not to seek judicial protection, di chiedere o non chiedere tutela giurisdizionale from the chosen or not chosen court by concluding a contract. In italiano contratto, in German materiellrechtliche Vertrag. In particular, the parties may stipulate either only the choice of forum agreement or both the agreement and the contract. The question of whether the parties have also entered into the contract is a matter of construction, to be resolved on a case-by-case basis in accordance with the rules of contract interpretation of the law applicable by virtue of the national norms of private international law. A brief parenthesis. One may wonder why I have mentioned national conflict of laws rules and not the European regulation Rome 1. I think that the regulation is inapplicable under Article 1, paragraph 2, letter E, which excludes from the material scope of the European instrument agreements on the choice of court. This term must be interpreted broadly to cover agreements having substantive as well as procedural effects, since the regulation also applies in a common law country, namely Ireland, which has a substantive concept of jurisdiction agreements. The exclusion rule contained in Article 1, paragraph 2, letter E regulation, then also applies to agreements which create rights and obligations for the parties, and thus to the contracts we are now examining. In order to establish the existence of such a contract, it may be relevant, for example, whether the parties provide for a penalty to be paid if one of them seizes a court different from the chosen one, or whether they state that an action for damages caused by seizing a derogated forum falls within the scope of their agreement on jurisdiction, or more simply, whether they include in their exclusive jurisdiction agreement a statement that they are obliged to seek judicial protection only in the chosen forum to the exclusion of any other. Once it has been established that the parties have concluded such a contract, it must be determined whether it is valid or null and void. In the Italian legal system, in my opinion, it is valid under Article 1322, second comma of the Civil Code, as it pursues interests worthy of protection under the Italian legal system, interessi meritevoli di tutela secondo l'ordinamento giuridico. In fact, it makes a choice of forum agreement more effective. In the event of a breach, the parties are certainly entitled to the ex post remedy of damages. A more complex question concerns the ex ante remedy, that is to say, the remedy that one of the parties may seek when the proceeding brought by the other party in breach of the agreement is still pending. Such a remedy is known in Italy as azione inhibitoria, in Germany Unterlassungsklage, which is analogous to an anti-suit injunction at common law. This action is inadmissible if the chosen court is located in another EU member state, according to the ECJ decision Turner against Grovit. However, in my opinion, in Italian legal order, it should be admissible and well-founded if the parties stipulate their agreement in favor of a third country's forum. It is worth noting that the conclusion of the contract is not relevant for the court in order to determine its jurisdiction, but only in order to decide on the merits of the case when a party seeks one of the above-mentioned remedies. I already argued this position in my monograph on the subjective profiles of jurisdiction agreements. In particular, in the first volume on the nature, effects, and law applicable to such agreements, I held that in civil law systems, choice of court agreements as such have only procedural effects, which are determined by the rules that provide for them, and are therefore exclusively procedural in nature. I also held that the parties to these agreements may enter into a contract which creates rights and obligations for them. However, this position is not universally shared. On the contrary, there is a widespread view in civil law countries that choice of forum agreements are sources of rights and obligations for the parties. This is, for example, the view of many German legal scholars, for example, Hans-Jürgen Helwig, considering procedural agreements in general, Peter Schlosser, Peter Gottwald, Reinhold Geimer, Burkhard Hess, and finally, Evgenia Pfeiffer and Jennifer Antomo, who have dedicated their monographs to this topic. This is the view of some Italian legal scholars, Niccolo Trocher, with whom I had a private conversation in this subject, is a young legal scholar, Giacomo Pailli, and last but not least, Elena D'Alessandro. It is the view of the Spanish Tribunal Supremo, and finally, of the German BGA, which in an important judgment of 17th October 2019 held that the jurisdiction agreement has always to be regarded as giving rise to a well-founded claim for damages in the event of its breach, even if this is not expressly provided for by the parties. In the opinion of the legal literature quoted and in the decisions of the above-mentioned courts, we can find 4 main arguments in favor of the substantive nature of jurisdiction agreements. I will call them the effectiveness argument, the interpretation argument, the bargain argument, and finally the comparative argument. According to the first argument, jurisdiction agreements should always have substantial effects in order to enhance their effectiveness, that is, to avoid, as far as possible, the breach of the agreement by each of the parties through the penalty of damages. This argument is based on 2 implied premises. The first is that the effectiveness of jurisdiction agreements is a matter for the legislator. And the second, that the legislator can make jurisdiction agreements more effective only if it regards them as a source of rights and obligations for the parties. The second premise is false, since there are other ways of achieving such a result. For example, the European legislator has introduced Article 41, paragraphs 2 and following in Regulation number 1215 of 2012, without recognizing rights and obligations as effects of the choice of forum agreements under Article 25 of the regulation. The first premise is generally not correct, since apart from the European legislator, national and international legislators do not seem to care about making choice of forum agreements more effective, since they have never enacted specific rules to achieve this result. We can then say that effectiveness of jurisdiction agreements is rather a matter for the parties, but if that is so, they are perfectly free either to make their agreement more effective or not, and thus either to conclude a contract in addition to the agreement or not, a contract which gives rise for them to rights and obligations. Let us now turn to the interpretation argument. A version of this argument was used by the BGA in its judgment, thereby adopting a position that appears to be similar to that taken by Evgenia Pfeiffer in German legal literature. The German Supreme Court held that an exclusive jurisdiction agreement must be interpreted to mean that the parties are under an obligation not to bring an action in a court other than the chosen one, and that a breach of this obligation gives rise to a well-founded claim for damages. Thus, according to the BGA, the interpretation of jurisdiction agreements would always lead to the same result, regardless of the particularities of each case. This is not correct, however, because the interpretation of a legal act works on a case-by-case basis, reaches different results in different situations, and cannot lead to the same result in all cases. Thus, despite its assertion, the BGA did not in any way interpret the agreement relevant to the case at hand, but rather determined the typical content and effects of any forum selection agreement, thereby exceeding its powers, since it is the exclusive task of the legislator to determine the typical effects of such agreements. Another, in my opinion, more refined version of the interpretation argument has been proposed in the German legal literature by Peter Schlosser. And developed by Jennifer Antomo in her monograph on the claim for damages for breach of a jurisdiction agreement. They think, if I have understood their idea correctly, that a jurisdiction agreement have obligatory effects unless the parties provide otherwise in the agreement itself. They therefore assume that a presumptio juris tantum exists to be used in interpreting jurisdiction agreements. Nonetheless, such a presumptio can only be established by the legislator, which, on the contrary, does not provide for it in any way. This is then an unacceptable presumptio juris tantum created by the legal interpreter. Let us now consider the bargain argument. According to this argument, the agreements on jurisdiction contained in a contract, and therefore the jurisdiction clauses, are a substantial portion, a vital part of the contract. As part of the overall agreement, as part of the overall bargain between the parties, they have the same importance as the other contractual provisions. They are then sources of rights and obligations like any other clause in the contract. In response to this argument, I would like to point out that, firstly, the argument at issue takes into account only jurisdiction clauses and not other jurisdiction agreements, namely those one relating to non-contractual disputes or those one concluded after the contract and relating to specific and determined contractual disputes. Secondly, it takes an economic rather than a legal perspective. Indeed, only from an economic point of view, it can be said that the jurisdiction clause is part of the contractual bargain between the parties. From a legal point of view, the jurisdiction clause is rather an agreement that is separate, autonomous, not just severable, as in common law systems, from the contract to which it refers. Since the two legal acts, the contract and the jurisdiction clause, are different in nature and effect. Finally, the comparative argument examines the concept of jurisdiction agreement in common law systems, where such agreements are regarded as substantive in nature because they are considered sources of rights and obligation for the parties. It then emphasizes that there is nothing to prevent this concept from being accepted in civil law countries, so wishing that a legal transplant will take place. In my view, this legal transplant is not possible for at least two reasons. First, in civilian systems, choice of forum agreements are procedural in nature, and therefore cannot have two different and mutually exclusive natures, both substantive and procedural. Second, the common law concept of jurisdiction agreements has legal historical reasons unknown to civil law systems. The common lawyers, and in particular the English lawyers, regarded the choice of forum agreements as sources of rights and obligation in order to give effect to such agreements in a system governed by the non-host doctrine, according to which private individuals could not, by their agreement, host the jurisdiction of the courts, which was regarded as a manifestation of the power of the sovereign. Nowadays, in European civil law systems, many rules allow the parties to create, prorogate, or extinguish, derogate the jurisdiction of the courts by their agreements. So, in these systems, recognizing the substantive nature of choice of forum agreements is not necessary, since they already have effects by virtue of such rules. Having examined these four arguments, I can conclude that none of them, in my opinion, is valid to justify the dual nature and effects, procedural and substantive, of choice of forum agreements. So, I remain convinced that my position is the preferable one. Thank you for your attention.
Thanks a lot, Luca. After all, choice of forum clauses are probably the most ancient form of procedural agreements, and they still keep on being debated upon. I would share your opinion, by the way, for what it matters. Now, we are back almost on time, and it is my pleasure now to give the floor to Guillermo Schumann Barragan. I don't know if I pronounced the name well, from the Universidad Complutense of Madrid. It's a pleasure to welcome you here in Catania. You will talk to us about procedural agreements and smart contracts, and the floor is yours. Thank you.
Well, thank you very much. Good afternoon. First, I would like to thank to Alessandro for inviting me, of course, to this seminar. That I have to say, I have to confess, I'm very excited to share this day with all of you. So today I would like to talk to you about the impact of smart contracts of judicial legal protection, and therefore the impact of smart contracts in civil proceedings. I have to say that I studied this topic for my PhD thesis and also for other publications, but my book on procedural contracts went to press at the beginning of 2022, just as Professor Wagner published a very interesting article about the algorithmization of enforcement that I was unable to include in my final text, so now I would like to pay tribute to this text as well. So I would like to start with two examples. Example 1. A and B enter into a contract in which they agree that when the ship Queen arrives at a port in Valencia, A will be paid B a sum of money for the transportation of the goods. The ship Queen has a geolocalization device that sends an order to a computer program that automatically transfers the money when the ship arrives at its destination. Example 2. A company placed in Barcelona rents a house to B through a mobile application that activates a code to open the door. The system automatically charges a monthly receipt with the rent to be paid according to the number of days, and this receipt is automatically charged to a credit card. At the end of the agreed period, or because of the non-payment of the last receipt, the system automatically blocks the access to the house. I have to say that I used the service of this company this last summer in Barcelona. So, a smart contract is a contract in which there are performances that are automatically executed by a computer program. So the automatic execution of part of the contractual terms represents a change in the normal private law dynamics and has procedural but also substantive implications that are interesting to examine. First, the automatic enforcement of all or part of a contract by a computer system makes it necessary to examine how the active and the passive legal positions underlying a contractual relationship works. As you well know, the creditor of any legal obligation has the right to demand performance from the debtor. This legal power is the substantive claim. To enforce this power, the legal order provides the creditor with different judicial but also out-of-court coercive measures. The main measure available to the creditor is to enforce the substantive claim through the courts. So the creditor has the fundamental right to seek effective judicial protection. But exceptionally, the legal order allows some mechanisms by which the creditor can satisfy his claim out of court directly by himself or by a third party. These are cases of self-help or private enforcement of the substantive claim. These instruments are used to obtain the out-of-court performance of the debt that has not been voluntarily performed. What is interesting here is that it is possible that these mechanisms of private enforcement of the substantive claim may be a result of the contractual arrangements between the parties. They are the so-called by the Spanish Supreme Court contractual measures to ensure due performance, medidas de aseguramiento de la ejecución contractual. So measures to ensure due performance are instruments that allow the creditor to satisfy his claim himself or through a third party. So they enable the creditor to obtain, without the intervention of the debtor, the due performance resulting from the obligation. A traditional example of this that is very common in the traffic is the escrow agreement. By the escrow agreement, a party gives a thing to a third party, the escrow holder, so that if the condition that is set out in the contract is met, the object will be delivered to another party. But if the condition is not met, the third party returns the thing to the owner. So smart contracts are another example of these measures. The contractual terms agreed by the parties are translated into code. So the algorithm is the translation of the legal contractual terms into computer code. Therefore, the execution of the algorithm implies the automatic execution of the contract. The possibility for the creditor to satisfy his interest on his own through smart contracts or other contractual measures to ensure performance changes the dynamics of enforcement of private law. As you well know, there is a series of substantive, procedural, and economic burdens that are legally or de facto imposed on those who seek judicial relief. For example, the collection of sources of evidence, the costs associated with the representation and defense, the statute of limitation of the right, that is, the time within which the holder has to react, the procedural burdens of allegation and proof that the plaintiff normally has to bear, among many others. These burdens make up what it is known as the burden of the judicial claim or the burden of the initiative. Of course, the idea of the burden of the initiative is closely linked to the status quo. Those who have the status quo against them will have an interest in seeking judicial protection. And someone has the status quo on their side if they have the possession of the thing or the money. So, as we know, at least in theory, In any legal dispute, any of the parties of the contract may take the active or the passive position in the proceedings. For example, through the exercise of positive or negatory declaratory actions, both the creditor and the debtor could file a claim seeking a declaration of the existence or non-existence of the right. However, reality shows that due to the dynamics of the traffic and the status quo that typically result from a legal dispute, there are cases in which the procedural position of plaintiff or defendant is usually held by a person with a certain role: a landlord or a tenant, an employer or an employee. So the legal order must take into account this status quo to regulate which party should bear the burdens and also to allocate risks. It is possible and sometimes desirable for the lawmaker to design the substantive and the procedural legal order to reduce or to increase the burden of the initiative on a particular person and a particular procedural role. For example, the plaintiff tenant or the defendant tenant. The burden of proving certain facts could be reduced procedurally by regulating mechanisms of access to evidence, presumptions, but also interim truths. Economic burdens may also be reduced by inter alia, special legal cost regime, or free legal aid. Summary proceedings and interim measures are also typical means for achieving a quick change in the status quo. Smart contracts, like most of the contractual measures to ensure due performance, involve a reversal of the role that the parties to a contract will normally have to assume in the event of non-performance. And, as I have just said, this change is caused by the status quo resulting from the out-of-court enforcement of the substantive claim. In principle, in the absence of contractual measures to ensure performance, it will be the creditor who would have to seek the protection of the courts, assuming the role of plaintiff with all the burdens that this entails. But if these measures are in place, the creditor can satisfy his interest himself. So in this case, it will be up to the debtor to seek the protection of the courts if he believes that the creditor was not entitled to receive performance. In this way, the debtor will end up assuming the position of plaintiff with all the burdens that this entails. And this leads to a change in the legal position to be primarily protected, a change in the burden of the initiative to seek judicial protection, but also a change in the allocation of risks. Strictly speaking, contractual measures to ensure due performance and also smart contracts do not imply a reversal of the material burden of proof. And this is something that Professor Wagner makes very clear in his article. Because if the contract is automatically executed and the debtor wants to go to court, the causes of actions will consist on the unlawful use of the contractual measures by the counterparty or in the termination of the contract because the other party did not fulfill his obligations, la exceptio non ad impleti contractus. And these are the same arguments that the debtor will use as a defendant, but also as a plaintiff. However, the protection of the creditor through the typical actions for non-performance is transformed into the protection of the debtor against possible unjust enrichment or undue payment, which always involve the restitution of the service and the goods that has been already provided or supplied by the smart contract. So strictly speaking, the burden of proof is not reversed, but there is a change in the legal positions and in the very judicial protection that is sought, at least for the debtor. The change in the roles associated with the out-of-court enforcement has multiple and important implications. One of them could be the regime of the restitution of benefits, because sometimes the regimes of restitution of benefits resulting from the nullity of a contract or for unjust enrichment could be different, or at least could be different in very specific issues. Also, there is a change in the allocation of risk associated with the time required to achieve a change in the status quo by judicial enforcement. For example, the risk of loss of the thing, the risk of loss of the value of the thing, but also the risk of insolvency of the party who should return the benefits. And for me, these are one of the most important effects that a smart contract has on the private law dynamics and also in civil proceedings. Smart contracts have an impact on other fundamental institutions of private law. In this context, it's particularly interesting to examine the impact on possession of the function of blocking things, which is included in some smart contracts. The Internet of Things makes it possible to connect different devices to the network and thus to trigger mechanical reactions in the analog world from the digital world. This allows to execute a blocking of things function that sometimes could crash with the possession of things. It is well known that there is a right to possess something, but possession is also a fact. It's a factual situation of power over a thing which, whatever its origin, is protected by the legal order. And whoever possesses something, whatever his right to it, is protected by the law. He has the right to continue to possess it, or at least to do not lose possession by force. So let's see two examples. Example 1. A rents a house to B. At the end of the agreed period, A changed the lock of the door so that B cannot enter in the house. In this case, A may be guilty of a crime of coercion, Article 172 of the Spanish Criminal Code. And I have to say that this type of criminal proceedings is very, very typical in Spain. Example 2. A is a multinational company that rents a house to B via a mobile application that activates a code to open the door. At the end of the agreed period, or in the event of non-payment of the rent, the system automatically blocks access to the house with the code associated with B. And I have to say that this type of contract is very, very typical in Barcelona. So, from the point of view of the prohibition of self-help, a distinction can be made between case 1 and case 2, because preventing the use of the thing at distance excludes the use of force against the debtor resistance. In reality, however, both cases involve an interference with the actual possession of the thing. Smart contracts with the function of blocking things will require a careful consideration of their compatibility with this. And one last point that I want to share with you. As you know, the rules of unseizability of access in enforcement proceedings pretend to preserve the dignity of the person against the coercive action of the state. The use of smart contracts or other contractual measures to ensure performance could allow the creditor to circumvent these provisions with a sort of private enforcement. See again two different scenarios. Example 1. A is a graphic designer and uses a computer and a software for his work. In the event of non-payment of some of the software license fees or the leasing fees for the computer equipment, the company blocks the use of the software and the computer. Example 2. A has a smart fridge connected to the internet as part of a leasing contract. A do not pay the last bill and the company blocks the fridge from opening. Cases 1 and 2 are specific considering the provisions of the Spanish Civil Procedural Code as non-seizability of property. And the fact is that even if there is no legal attachment for the payment of the debt in these two examples, which will allow us to speak of a private freezing, de facto, the thing is rendered unusable. According to the German doctrine, this is a kind of cold seizure. So, in this way, and it must be emphasized that there is no legal seizure, the function of blocking things activates or could activate the ratio legis underlying the rules of unseizability of the civil procedural codes to guarantee the debtor the use of some access essential for his life. The consolidation of smart contracts incorporating the blocking function may require provisions that ensure the protection of the debtor that the rules of non-seizability serve in enforcement proceedings. In one case, the aim is to protect the debtor from the enforcement action by the state, and in the other, to protect the debtor from the enforcement action of the creditor. This can be done by means of rules preventing the blocking of the use of certain things, or directly by excluding certain things from the debtor's liability. It is a matter of overcoming the dogma of the separation and maintaining a unified vision of the legal order and the principles and values on which each of them are based, something that procedural contracts has always taught us. So, thank you very much.
Thanks a lot, Guillermo. It's really amazing how today we've dealt with traditional topics and future topics in such an harmonious way. This look into smart contracts and their implications with civil procedure is fascinating. On a purely personal basis, it reminded me, this year I was somewhere on holiday, and of course there was some code on the door of the room, and the people the renting people told me, after 12 on the living day, you will not be able to access any longer. So that put a lot of pressure on me. I thought, well, I could stay here and not ever get out, but I think, well, anyway, that's just a joke, of course. But yeah, the future from this point of view, it's a little bit scary in a way. But let's be positive. And now, I don't know if there is time for questions before. Yes, I think that we have 2 minutes. No, this has been a very dense afternoon. But if there, if there are questions or anybody willing to take the floor for a couple of minutes, it will be perfectly fine. But if nobody wants to stand up for that, I will gladly give the floor to the man in charge, to the person in charge of this very successful event, I would say, Alessandro Fabbi, who is professor here at the University of Catania. Everybody thanks him for organizing this event. And now your conclusive remarks.
Thank you, Michele. Thank you very much indeed. I greatly appreciate all the thanks from all the friends present here. But I have no merit but that of having gathered here in Catania those who are the national and international, probably worldwide major experts in this topic that we are dealing with today. It is I want to thank you all for this, and as well as I want to thank my university, which for years today has shown me a lot of affection, I would say. So moving rapidly on what counts to us, I want to say few conclusive words, because today we have touched general lines of the procedural agreement, as well as very specific issues, mostly complicated issues. And all of the speakers made these issues so simple. This is a credit to them, of course, but this is also, as we should have learned, if today the first time, that doesn't matter, a proof of the globality of this topic, of the global character and interest to this topic. The reflection on procedural agreements, I will shortly mention that affects my life path in parallel with my research path. And I will make references to both, very scarce reference instead. The speakers, as I said, have dealt with global and particular aspects. And this global tendency, we have to say, runs the risk to be labeled as liberalist in procedure. We are too liberal, we don't want the judges anymore. Maybe it is not like this, but it might be for this exactly that usually the research and reflection regarding procedural agreements start always, or most in all cases, by the research regarding their limitations. The first question we usually put to ourselves is, can we really do this, and what are the right and appropriate limitations to this? Regarding this, very generally speaking, I will make then two conclusive points which are intertwined, connected, and they both touch with, once again, the idea of procedural autonomy, which has been sketched already, and with a third and last point, which is a consequence. So the first 2 points, I have to start from the adversarial principle, which is in civil matters, in civil procedure, is shared today by all modern procedural legal orders and legal systems. And it is usually reconstructed, conceived as the projection of the, we can say, but in English it doesn't really give the effect which is wanted by the continental equivalent. We can say to be a projection of the waivability of the substantive right when it comes with the civil process. This can mean that the civil process is in the hands of the parties, and of course the answer is no for everyone. And I can quote, among others, our prominent Italian jurist Satta, who used this very helpful expression to express the idea when he used to say that there's no automatic passage from the, let's say, availability of the substantive rights to the availability, or supposed to, of the civil process, but a jump, he used to say. I have, at this regard, a personal memory to tell shortly. My first comparative approach to procedural agreements was when I studied this topic in the North American system. And I was 2 times lucky. First, I had the fortune to reflect about it at the side of important masters of civil procedure there. Second, especially when I went there and I didn't know that from before, I immediately discovered that the topic was a hot topic those years. They were discussing this, and those were the years of the U.S. Supreme Court's decisions on class action waivers, arbitration agreements in serial consumer disputes, and so on. They were in trouble with this because we all know, everyone knows that North American civil procedure is more than any other model of procedure an adversarial one. It is party initiated, controlled, and driven. And they obviously started to investigate possible limitations to this, and they tried immediately to rebut the presumption that this adversarial approach to civil procedure could result in the parties being free to contract whatsoever during the civil process. And that was in fact happened. I had this chance to discuss with them, and they were respectively looking for literally a public law protecting argument there with the adversarial principle conception that they have always believed in. And second, they told me we still need judges. That's not the case to explain and discuss how things went over there, because whereas, very in short, the scholarship at the end of the day found some solutions to this also there, that was not the case and still is not the case, and it seems, with the case law, with real life. August 2024, this year, you may have read in the Guardian, New York Times, and so on, the same sense. Titles in the sense that all more or less saying, okay, am I waiving my rights to sue Disney by simply clicking, or maybe not ever clicking or signing anything, their terms and conditions? To be honest, something very sad happened because a man died due to food allergy in a Disney park. And when the heirs started a lawsuit to ask compensation for damages, Disney immediately objected the existence of this clause, which was an arbitration clause, and probably, but we don't really have time now to deepen the aspect, contained also a class action waiver. That's to say simply that this is happening, but I think that today at least is the true evidence for real. This story of a serial contractual relationship leads me rapidly to the second point, as I mentioned, intertwined with the first, connected, but reversedly with the adversarial principle and approach of civil procedure in modern legal system. Usually, always in continental modern legal systems, and we have reason for this, serious reasons for this, we regulate the civil process with a different balance of powers when it concerns, on the opposite view, non-waivable substantive law relationships or rights, or let's say it in a simple way, when it regards particularly delicate situation, substantive law situation. In these cases, procedural law is used to counterbalance the disparity of powers, the unfairness in these relationships which does not present the parties at the same level and so on. There's a public interest, generally speaking, to do this when there's a minor or when there's a third party outside of the agreement and so on. But as it is not true that the adversarial principle can result in the parties being free to contract whatever they want, I have to say that, and today is an evidence to this once again, that it's not even true that when the non-waivable right is involved in the civil process, procedural agreements or any other amount of procedural control of this kind of our interest today is forbidden. But it results to be a procedural technique and leads us once again to the counterparty of the limitation to the agreements, which is the judge and its oversight, which sees the judge on another level and plane. And maybe this helps, that's not the case and the time today enough, to clarify that this judge probably is not a party to this agreement, as substantive law criteria should or could guide us asking ourselves. The third point is just a consequence of the first two. Of course, procedural agreements, and we have learned this today, or repeated this today, need operational tools, mechanisms. They have to live in the civil process. They imply this mechanism when it comes to especially non-fulfillment of the agreements, on its annulment, and so on. Comparative law at this respect can help, but only to some extent, because of course this investigation has to be made in the specific national system, case by case. Second hand, comparative law can help, however, if we keep in mind where the single system that we are comparing was born, basically, in history, and what are the original connections of this system with the other one put under comparison. A few final words on our system, my system, the Italian one, because we have seen today that if ever a proof was needed, the agreement is a category of the civil process today in many systems. Little or not all in this context there's the importance given to the topic and to the agreement as a category in the Italian case. But this is only apparently fair enough, because in short, the Italian system as well shows a number of recurring paradigms, models, procedural tools, sometimes hidden in the provisions or contained into, to be honest, obsolete provisions, which could be the basis and probably are still today, already today, the basis of a proper study and construction of procedural agreements. The reasons for this lack of attention are, to my humble opinion, less profound than we would believe. And it's not our interest today to deepen them, but they are all, this situation is very easily bridgeable, always to my opinion, if we put ourselves in the perspective that today, I have to say once again, has been masterfully explained by our guests, that the agreement, first, it's already a part of reality. Second is an instrument of efficiency. We are not pursuing liberalism in itself, and is capable to reduce procedural issues because it touches procedural nullities and so on, pursuing therefore a decision on the merits. And third is it was said before, I want to repeat this, it's not an enemy of justice but a friendly instrument which, and as in the same way all these friends who gathered here today have showed us until now. And with this, I want to conclude and say to all of you, thank you once again. Thanks.
No. Al mio ruolo. Ah, okay. So I have the final word. Yes, and the final word is have a good evening in town. Enjoy the weekend. Thank you.